Imagine waking up in a city where sleeping outside is illegal, but there aren't enough shelter beds for everyone who needs them. What happens when basic human needs collide with municipal law? This exact scenario played out in Grants Pass, Oregon, and ultimately reached the highest court in the land, resulting in a decision that's reshaping how cities across America can address homelessness. On June 28, 2024, the United States Supreme Court delivered a landmark ruling in City of Grants Pass, Oregon versus Johnson. This case addressed one of the most pressing questions facing American cities today. Can municipalities legally prohibit people from camping or sleeping in public spaces, even when there aren't enough shelter beds available? To understand the significance of this ruling, we need to step back and examine what led to this legal showdown. Grants Pass is a small Oregon city with a growing population of unhoused individuals. Many of these people had no choice but to sleep in parks, on streets, and on sidewalks, creating visible encampments throughout the city. Faced with this challenge, Grants Pass officials did what many cities have done. They passed ordinances making it illegal for people to camp or sleep in public spaces. The penalties started with fines, but repeated violations could land someone in jail. Here's where the legal complexity begins. The number of people experiencing homelessness in Grants Pass exceeded the number of available shelter beds. This situation created what legal experts call an impossible choice. People had nowhere legal to sleep, yet sleeping in public was against the law. The unhoused residents of Grants Pass found themselves caught in a legal trap with no escape route. The case that reached the Supreme Court began when several homeless individuals challenged these ordinances in federal court. They argued that punishing people for sleeping outside when no shelter beds were available violated the Eighth Amendment's prohibition against cruel and unusual punishment. Their argument wasn't without precedent. Lower courts had previously ruled that cities couldn't criminalize sleeping in public if they lacked adequate shelter space. These decisions were based on the principle that the government shouldn't punish people for conduct they have no realistic way to avoid. The legal foundation for this argument came from a 1962 Supreme Court case called Robinson versus California. In that decision, the court ruled that states couldn't criminalize someone's status as a drug addict. The Robinson case established that the Eighth Amendment prevents the government from punishing people simply for being in a particular condition they cannot control. Homeless advocates argued that sleeping is a universal human need, much like the addiction addressed in Robinson. They contended that when cities provide insufficient shelter space, they're essentially criminalizing the status of being homeless, which should be unconstitutional under the Eighth Amendment. However, the Supreme Court saw things differently. In their June 2024 decision, the justices rejected the argument that anti-camping ordinances violate the Constitution. The court's reasoning centered on several key distinctions that fundamentally changed how we understand the relationship between homelessness and criminal law. First, the Supreme Court clarified what constitutes cruel and unusual punishment under the Eighth Amendment. The justices explained that this constitutional protection applies to the methods and proportionality of punishment after someone has been convicted of a crime. It doesn't prevent cities from defining what conduct is illegal in the first place. The court emphasized that the Eighth Amendment historically focused on barbaric punishment methods, excessive fines, and disproportionate sentences. It wasn't designed to limit what activities governments can criminalize, as long as the resulting punishments aren't cruel or unusual. Second, the Supreme Court made a crucial distinction between punishing someone's status and punishing their conduct. While Robinson prevented states from criminalizing the status of being a drug addict, the court ruled that Grants Pass wasn't criminalizing the status of being homeless. Instead, the justices determined that the city was prohibiting specific acts, camping and sleeping in public spaces. The court reasoned that these are actions people choose to take, not involuntary conditions they cannot control. This distinction proved pivotal in the court's analysis. The Supreme Court rejected arguments that homeless individuals had no choice but to sleep in public. The justices noted that people could potentially sleep in other locations, even if those options were limited or undesirable. The court declined to recognize a constitutional right to sleep in public spaces simply because preferred alternatives weren't available. Justice Neil Gorsuch, writing for the majority, emphasized that federal courts shouldn't micromanage local policy decisions about addressing homelessness. The court expressed concern that constitutional restrictions on anti-camping ordinances would handcuff cities trying to maintain public order and safety. The decision also reflected broader questions about the proper role of federal courts in addressing social problems. The majority suggested that homelessness is primarily a policy challenge that should be addressed through legislative and executive action, not constitutional litigation. Justice Clarence Thomas wrote a separate concurring opinion that went even further. He argued that the court should reconsider the entire Robinson versus California precedent. Thomas contended that when the Eighth Amendment was ratified, punishment referred specifically to penalties imposed after criminal conviction, not to the definition of criminal conduct itself. This concurring opinion signals that some justices may be willing to narrow constitutional protections even further in future cases. Thomas's approach would give governments broader authority to criminalize various behaviors without Eighth Amendment constraints. The practical implications of this decision are already being felt across the country. Cities that had been constrained by lower court rulings can now enforce anti-camping ordinances more aggressively, regardless of shelter availability. Some municipalities have already announced plans to clear homeless encampments and increase enforcement of public sleeping bans. Supporters argue this will help restore public spaces and encourage people to seek services and housing assistance. Critics worry that the decision will lead to a criminalization of poverty, pushing vulnerable populations into the criminal justice system without addressing underlying causes of homelessness. They argue that jail time and fines don't solve housing shortages or provide mental health services. The ruling also highlights ongoing tensions between different approaches to addressing homelessness. Some advocate for housing-first policies and expanded social services, while others prioritize public order and enforcement-based solutions. What's clear is that this Supreme Court decision has fundamentally altered the legal landscape surrounding homelessness in America. Cities now have broader authority to regulate public spaces, but they also bear greater responsibility for developing comprehensive approaches to help their most vulnerable residents. The Grants Pass decision represents more than just a legal ruling about camping ordinances. It reflects deeper questions about how American society balances individual rights, public safety, local governance, and social responsibility in addressing one of our most persistent challenges.